Greetings, welcome one and all to the Lincoln Lawyer channel. Thanks for coming. Today, a fascinating topic of discussion, sure to delight the masses. We will be discussing non-disclosure agreements or confidentiality agreements or NDAs as they are affectionately known. So these things are all the bustle of the town after that feisty debate where Warren called out Bloomberg for supposedly oppressing his former employees with these documents. So I'm going to go ahead and discuss these things in general detail, and then we're going to look at some provisions that they will likely have. So give you ways to think about them, and then we'll call it a day pretty much. Okay, so let's get started. Everybody watching this video is likely to have signed or will sign an NDA in their lifetime. Everybody you know will probably end up signing an NDA in their lifetime. These things are absolutely ubiquitous, and I'm here to tell you they are essential. They are extremely important. I cannot overstate it. I cannot overstate how important these things are for the proper functioning of business. So I've done thousands of these, reviewed them, drafted them for all kinds of parties, both employer and employee, for company ventures, etc. So I would like to think I know what I'm talking about, but never know. So these things are used generally with employees, contractors, consultants, between companies, pre-venture due diligence, all kinds of due diligence, mergers, acquisitions, etc. So pretty much any kind of confidential information that is going to be released, you need to have a safety valve there, okay? It's very important. Because companies don't want competitors poaching their employees and using that information to destroy them eventually, okay? Because that can easily happen. A person goes to work for a competitor, get a higher salary, they disclose all the financials, the patents, the developments, the weaknesses of their former employer. It's over. I mean, within a couple of years, that company could be out of business. That's how easy it is. So one situation we can take a look at, an example where this kind of occurred, was the recent lawsuit between Google and Uber. This was a major lawsuit, took about a year. This occurred where Uber purchased a company where a former employee of Google's subsidiary that was working on a self-driving vehicle AI stole a whole shitload of their files and opened this new company. Uber came along and took it, bought the company, took all their AI and used it in their own program. So Google sued, eventually they settled. Uber agreed to give Google's subsidiary a small stake in their own subsidiary. It was a couple of $100 million. So it was pretty contentious, and it was discovered that basically Uber had planned this whole thing even before the employee left. So it was a big mess, and it was clear breach of the non-disclosure agreement. But honestly, I think very little of Uber in general. I think it's a despicable, disgusting company. I don't think they care about their customers. I don't think they care about their contractors. Their whole goal is to automate their fleet. They want to get rid of all their contractors. They want the self-driving program in place as soon as possible so they can become profitable, which would become profitable so they don't have to pay these people. They don't give a shit if they put, a couple of million people out of a job. So they didn't want to work for it. They didn't want to invest a couple of billion, since they're losing about $1 billion a year. They didn't want to invest that money in a development research program for AI. So they just went ahead and, they stole it from Google. And so that's how they do business. So getting a little bit sidetracked here, but so you can see that NDAs are not perfect. Okay, people will breach them. They don't care. They'll breach anything for money, any agreement. So you can look at all the litigation that goes on between Apple and Samsung. It's never ending. It's constant. I think they have like hundreds of lawsuits pending at the same time right now. They've been litigating for like over a decade. Ever since Apple started, they were accusing each other of stealing this icon and this technology, whatever. So that's not everything that involves NDAs, but some of it involves NDAs, obviously. But a lot of it just involves corporate espionage. And there's all kinds of ways to get confidential info, and certainly companies definitely try to do that. But NDAs are one shield in preventing other parties from taking confidential information and using it for themselves, because it provides a contractual remedy, a contractual basis for seeking an injunction, suing the breacher of that agreement. Okay, so basically there's two kinds of NDAs. There is the unilateral and there's the mutual. Okay, unilateral, obviously, that's where one party has the power of leverage over the other, and they're not going to be bound by any confidentiality, and so only one party is going to be bound. Generally, it's employee agreements, contractors, consultants, that kind of thing, salespeople, contractors. So, and mutual are generally used with two companies that are going into a venture together, or mergers, acquisitions, that kind of thing. But pretty much, it's not cut in stone. If both parties are going to be revealing confidential, private, proprietary information to the other, then the mutual should be used. So it's pretty basic, pretty straightforward. Okay, so let's take a look at some of the important provisions that you are very likely to see in your NDA. First of all, the definition of what is confidential needs to be relatively specific, and obviously the both parties or the employer also will want to keep that extremely broad as possible. So generally you need to assume everything is confidential. Just assume that, okay? Everything you learn during the deal, the transaction, the employment period, the relationship is going to be deemed confidential, subject to a few exceptions I'm going to get into in a little bit. So basically they're going to have a very general statement that everything, and then they're going to list specific items like customer lists, financial information, graphs, charts, data, anything like that. So additionally, these NDAs may include inappropriate conduct that occurred during the relationship. So of course that will include something like harassment, a hostile work environment, things like discrimination. Pretty much anything that's not illegal can definitely be concealed and deemed confidential. So illegal information is not, illegal activity may not be sealed, okay? So basically that's how they are used in general, and obviously the broader the definition of what is confidential, the stronger the agreement, the more things that need to be kept confidential. For example, if the employee was subject to harassment, to inappropriate treatment, then the greater the benefit that should accrue to that employee. So that they should receive greater funds, greater severance package, greater benefits, greater bonus, etc. That's just how it works. So the more one side gets, the more the other should get. Okay, so next item I'm going to discuss is going to be the time limitation. Every agreement is probably going to have a time limit. That time limit will generally be 1 to 3 years, but can also be indefinite. It can be permanent. Okay, so the more permanent it is, obviously the greater the payment should accrue to the signatory. Once again, okay, so permanent agreements are fine, but the payment should then be greater, okay? So let's talk about exceptions. This is going to include maybe 3 or 4 different exceptions. Exceptions are going to be things like information that was developed by another third party separately. That's not going to be deemed confidential, or information that's ordered, released by court order, by any lawful regulatory action. So that will not be confidential. But the most important one is going to be information that is made public through any means other than by release of the signatory to the agreement. So let's talk about this Bloomberg situation, where he is alleged to have made some comments, and these comments were released. They were leaked to the media. The media published them. Bloomberg discussed them. He either denied them or whatever. So basically, let's take the example of one comment where he told an employee to get an abortion, and basically that comment now does not fall under the NDA. It can now be discussed. Okay, so the employee that was subject to the NDA, she can discuss that particular comment and no other. She cannot disclose any other comments that he made or anything else he said. She can say, yes, he said that, or no, he didn't say that specifically. He said it like this. He said it a little bit different. He was nicer about it, whatever. He was ruder. So that is the limit. That is how it works. So if anything is made public that was confidential previously, it ceases to be confidential and may now be discussed without penalty. Okay, so that is one of the exceptions. Okay, additionally, injunctive relief. Companies will also want to be able to obtain a court order to prevent or to stop, to halt any sort of release of confidential information. So they will generally include also attorney's fees. So basically that gives them the leverage over the signatory. Basically, if they believe that confidential release, information release is imminent, they will go to court and they will seek an injunction, and then the signatory has to answer it. Okay, they have to get a lawyer, they have to put up deposit, they have to go answer it, fight it in court, or they're just going to get defaulted and get the injunction in the mail and an order to not disclose or to remove any information that was already disclosed. So, and also a legal bill. They're going to get a nice legal bill that is collectible by contract, just like any other bill, any other debt. So that is a problem. So definitely something to think about. Generally, people, they will breach these agreements. They don't care. They're not really afraid. They don't think the employer will find out. They don't think they'll sue, but you never know, because, they might want to make an example of a specific person, or they might deem the loss of specific information very important, and they'll just go to court and they'll tax the costs to the person breaching the agreement. So it can get very serious. Okay, so there's definitely a lot of questions, a lot of issues surrounding what an employee can use once they leave a company and they go work for a competitor, because people do transfer jobs, they work for competitors. This is especially common in the tech industry. Obviously, let's say an employee developed a process or a technology for an employer, and then they leave, they go to work for a competitor. Can that employee develop the same technology for that competitor? Well, it depends. It depends what tools and what data, what information was used to develop that tech or process for the former employer. So if company information, data was used, if other employees assisted, they worked with that particular employee, if the employee used the company's resources, any kind of information from the company, then no, he cannot do it. If the employee created that technology or process all from his or her own creativity, ingenuity, skill, expertise, and did not use any of the company's resources, then yes, they can recreate that technology for the competitor. So this is obviously a gray line. It can and has been litigated. So I can't really give any specifics as to that. That is generally how these things are treated, but there should definitely be some kind of valve on what information can be taken from a former employer and used for a new employer. Okay, so that is the injunctive relief. That's generally how it's used, and if the employee believes that they were wrongfully targeted by a former employer, they can go ahead and fight it and ask for attorney's fees, and if that happens, they might just get it. Okay, so now I want to get into a couple of provisions that you are likely to see in an NDA that are not related to confidential information. So the first one is going to be non-solicitation. Okay, this provision is extremely important, and you're probably going to see it in every single NDA. Basically, it limits the right of a former venture partner, employee, contractor, etc., anybody who has access to customer lists of their former co-venturer during that relationship. They are not permitted after that relationship to go back, call that person up and say, hey, look, I have the same damn product, it's 10-20% cheaper, they don't like you over there anyway, they made fun of you, they talk shit about you, ways to rip you off, whatever, so come over here, you have a better relationship. You can't do that. That's a no, no, no. That's going to be a big problem. Companies regularly enforce these non-solicitation agreements because customers are extremely valuable. They're expensive to come by, and these things are easy to enforce, and the damages are easy to calculate. Okay, so basically they'll sue, they'll get an injunction to stop you from contacting customers, and they'll ask for damages. You got to fight it. If you don't fight it, then you're going to lose damages and attorney's fees. You're going to have a big bill to pay. So basically, these are very risky to breach. I definitely suggest not breaching these non-solicitation agreements, not contacting former customers until they have left the former employer voluntarily or their contract term ends. Then do whatever you want. They're a free agent, not a problem. Okay, but if you do this during the time that the customer is still with the former employer, then you are breaching the agreement and you can be liable for a large amount in damages. Okay? So the final thing I'm going to discuss is non-disparagement. So this is the internet age. A former employee can easily get online, start talking shit about their bosses, their coworkers, the products, the company, etc., just completely wrecking its public reputation, damaging its goodwill, brand, etc. So this is a problem. Obviously, employers do not like this. They try to prevent this with the non-disparagement. This prevents any negative, derogatory public information from being posted publicly by the former employee or the co-venturer, the other company, whatever. So this is similar to non-disclosure, but it focuses solely on negative, derogatory information that would tend to damage the former partner's or employer's reputation, business, brand, goodwill, etc. So generally, honestly, these are difficult to enforce. There are First Amendment issues involved, okay? So companies generally do not sue on these, but they may, okay? So I'm not saying they never sue, but they may. So the First Amendment issue, and then obviously, you know, determined former employee, you're not gonna stop them. You know, they can go online and just, you know, be anonymous, post whatever they want anonymously. People are gonna pay attention anyway. They can say, yeah, I'm a former employee, you know, and this happened. This product is killing children. The company's concealing it, yada, yada. So, you know, the company, you know, it's not easy to find out who it is, but if they do find out who it is, then obviously they can sue this person and obtain an injunction, because that is a contractual remedy. Then they can bill them, you know, they can bill them for the attorney's fees and for any damages to goodwill, to the reputation. So this is hard to do again, but it is part of the NDA, and you should be aware of it. So I think I am going to wrap it up at this point. I hope this has been informative and interesting, or one or the other. And thanks for watching. Stop back soon. I will see you later. Be cool. Stay frosty.